Good afternoon, Council. This is the case of In Re K.T.B. Please enter your appearances.
Thank you. My name is Ryan Holdaway. I'm here on behalf of the appellants V.D.B and Jalal Norris.
Diane, put your co-quote, please.
Welcome.
Paul GOSNELL. I'm here on behalf of the Appellees, the adoptive parents.
Welcome, Mr. Gosnell. Mr. Holdaway, are you reserving 5 minutes?
I am, Your Honor.
Thank you. Let's proceed.
All right, thank you. May it please the court, my name is Ryan Holdaway. I represent the appellants in this matter. As your honors are aware, there have been the appeals have been combined with the motion to enforce. I didn't want to get too bogged down into the issues on the motion to enforce. I wanted to rest primarily on our pleadings in that regard. However, there was an argument that was raised in the reply for the first time that I feel compelled to address, since we haven't previously been able to touch upon that. In particular, just by way of context, in the opening motion from the Averys on that, in paragraph 7 of the statement of facts, they quote from a section of the mediation statement, which says something to the effect that all parties consent to the adoption of K.T.B. by the Averys. However, nowhere else in the memorandum does it touch upon that or argue that that somehow stands for the proposition that the motion to enforce should be granted. It was merely contained in the statement of facts and nothing more. To that extent, we didn't respond to that, as we didn't view that as an argument justifying the granting of the motion to enforce. In the reply, however, an entire section was then dedicated to that clause of the mediation statement, and it was suggested that it created a standalone and independent basis for granting the motion to enforce, and therefore I feel like I need to address that. I think by way of context as far as how that came to be, it's important to understand that at the time the mediation was entered into, V.D.'s parental rights had been terminated, the child had been adopted out, and she had no access to her son. Consequently, it was inherent in the negotiation process that the son more or less amounted to a negotiating chip, whereby her access to her son would require her to acquiesce to certain demands.
So are those facts that are in the record before us? I mean, if we're going to start talking about these sorts of things, isn't a remand the appropriate avenue to proceed?
Well, I'm not challenging the fact that that statement is contained in the mediated statement. It is in there, and she did sign that. So we're not contesting the fact. What I'm contesting is the argument, number one, that it's raised in the reply instead of in the original motion. That's one thing I'm contesting. The second thing is I disagree that that amounts to a grounds for an independent granting, or an independent grounds for granting the motion to enforce. One is, as I'm trying to indicate, I believe there's a certain element of duress, but I don't think that's the primary reason why it should be. Really what it comes down to is section 78B-6-124. The Utah Adoption Code sets forth very specific requirements, not only on who has to provide consent, but also as to who can take that consent. And that is contained in section 124. And here we get a clear distinction between mothers and children as compared to everybody else.
Do you take the position that this is an unenforceable agreement?
Yes, we do.
Do you take the position that it's unenforceable because it doesn't comply with section 146?
That's part of it, yes. That's not the entire argument.
So are you really advocating for a rule that says, let's say hypothetically the termination of parental rights has happened and the adoption has been finalized, but there's a challenge to that adoption, as here, and the process takes a couple of years, and in the process the parties are deeply concerned about the best interest of the child, and they say, you know what, we'll go ahead and consent to the adoption, but we as the biological parents will get significant visitation. We'll lay that out. Are you really saying that this court, the parties can't agree to that kind of deal and think about their children that way and try to do what's right for the children, and that that's not enforceable because it happened after the adoption was finalized and not before?
Yes and no. The yes part is to the fact that I believe that parents and adoptive parents can always cooperatively agree to do those things.
But you don't think they can enter into an enforceable resolution that would dispose of the appeal?
post-adoption, if it's going to be made pursuant to that specific section, no, I do not.
Well, not made pursuant to, just generally. I take your position that it's, you can't, in light of 146, you can't enter into this type of agreement. And I wonder if that's really the case. You say you parties post-adoption but pre-resolution by this court cannot enter into a settlement agreement.
Right, and I do think that, and there's a particular reason why. The requisites that are, the prerequisites that are built into that statute, that code, that would normally have to be in place if this agreement were being done
Seems like
pre-adoption.
horrible public policy.
I understand in that I play by the rules. I don't make them.
Well, but I'm suggesting when something smells of horrible public policy, I'm suggesting maybe there's a better and different way of reading the statutes.
Well, but I think there is some reasoning to the process, and that is, as we see in a lot of the cases as far as enforceability of agreements where we're talking about parents, or in this case adoptive parents, contractually obligating themselves to give access to their children to other people, they cannot deprive the court of its roles in ensuring that it's in the best interest of the child. They cannot do it.
Right,
Well-
counsel, now, I mean, under the terms of 146, as you know, this was not an agreement entered into during the pendency of the adoption,
That's right.
right? So why isn't the conclusion that we should draw from that 146 has no application then, and therefore we're purely in the realm of contract?
For two reasons. The first one is that the parties explicitly state that they're entering into it pursuant to 146, and they, in fact, copy numerous terms and reference that.
Well, but if they're wrong about that, I mean, they can say that, but it doesn't mean that 146 applies. I'm confused by the notion that once an adoption has been finalized, that parties could bargain away in a contractual sense certain of the decisions that they're entitled to make as legal parents, but the court would no longer have any authority to review those determinations unless, you know, there were abuse and neglect challenges and so on.
Therein lies the problem, and that's why I think there is some reasoning to Section 146 requirement that normally in the process you do this pre-adoption, the district court would weigh in and make a determination that it's in the best interest. This is a critical step.
I just don't understand how you can do it post-adoption.
You
I think
can't.
there may be constitutional rights in attempting to interfere with the decision-making
No.
of adoptive parents post-adoption.
And I agree. That's the whole issue. I think this is the problem, and I recognize because this is happening post-adoption and we don't have records of this in the district court. But everywhere, it's my recollection, all the way up, even through mediation, everybody, opposing counsel included, understood and agreed that it was likely not going to be enforceable, that it was going to be an agreement that the parties were doing more or less operating on trust, hoping to work something out.
Is it possible to read the statute to incorporate the appeal process under the concept of finalization of adoption so that as if here on appeal, challenging the adoption, we haven't resolved it yet, that we can stop the proceedings, remand for a 146 best interest determination?
I don't think so, because, I mean, from our perspective, since the September order, determination occurred. I mean, it has
But it
been
is
done.
being under, so it could be undone, right?
It can't be undone, but it wasn't stayed.
So
Like
if we
asked for it.
undo it, then you could enter into the agreement.
We could. I mean, but again, this goes back to the contextual issue of the fact that at the time, my client was operating under the belief that she had lost her rights. If my client's rights are restored and now she gets to have
So
her
you're
day in
telling us
court-
something that's actually extra record, and that might get my second point. You're making a duress-like argument, and you're also making an argument for breach. Don't both of those require factual findings that we're not very well positioned to make, and shouldn't we send this back down on your breach question? I mean, you guys are diametrically opposed on whether or not there was a breach.
That would be true only if this court felt like it had to get to breach as the way of resolving the issue. If it determined that because the court had never weighed in on the best interest analysis and because best interest hadn't been established, therefore there's actually no assurity at any point that it actually is enforceable. Because at any point, the district court...
But the parties, you know, independent of the application of 146, and the parties have said that anything inconsistent with that will be severed. And the contract will remain viable effectively. It says that. Also, the parties contemplate a best interest determination in the contract itself, right?
They do.
And isn't there a good faith obligation then to comply with the various conditions precedent and obligations under the contract and move it forward toward a best interest determination by the court?
I believe that if the court first finds that it is in fact a valid enforceable agreement, then you have the implied good covenant of good faith. But we
Where-
first have,
Could you just explain to me briefly, what's the jurisdiction of the trial court in enforcement of a post-adoption proceeding?
in this particular instance, it would have to be in the context of somebody tried to file a motion to enforce. Or, in fact,
With the district court, and that did not happen here, right?
No, it did not. And again, that's because we're of the position that, and we,
See, I just don't understand how a court just sort of can intervene in a familial situation without a grant of jurisdiction or continuing jurisdiction of some kind. And I don't know what jurisdiction a post-adoption court has in the adoption case to do anything with respect to best interest. Now, you have all kinds, or there are all kinds of arguments respecting whether the trial court in the first place,
Right,
denied
but-
due process rights and not.
right, but
taking
if
some-
I understand Your Honor's position, essentially what you're saying is it would not be enforceable because there wouldn't be a court to go to enforce
Well,
it
it
to
might be
begin with.
enforceable, but I don't know how parties can contract to have the courts resolve their differences when they don't have a pending case before the court.
Well, I guess in that case, what you'd look at is you actually have to literally file a brand-new complaint.
Right.
And open a new
Right.
case for breach of contract.
Right.
But we-
On an agreement that has no remedies.
We have often said that you can file an enforcement of a settlement agreement in the existing action, and you do have an existing action here, and that's what you're in front of us on. And they've asked us to stay these proceedings to get a determination of your settlement agreement, right? So it's not, I mean, it may be that the district court has been divested of jurisdiction because of the presence of the appeal, but it's not that there's not a pending action.
No, and I understand that, and I don't mind that, or taking that point of view of it. I think the issue that I'm coming down with, I was just trying to answer Justice Durham's question, but I think from our perspective
Yeah,
of it.
so was I through that
Yes.
question.
What's that? Yeah, I know, I agree. So here's the issue, is that ultimately, from our perspective, the reason language like 146 is so critical is because when the court comes in and weighs on it ahead of time and says, yes, the court agrees, this is going to be in the best interest of the child. At that point in time, assuming there's not a material change of circumstances that occurs thereafter, both parties walk away with some reasonable degree of assurance that the court would enforce that because it's already said, yes, we think that's in the best interest of the child. But until that happens, neither party knows with any degree of reasonable certainty as to whether or not the court will agree that it is in the best interest of the child. And what is more is you have an agreement, or an alleged agreement from my perspective, that says, number one, we're going to presume that the Avery's decision is in the best interest, whether it's consistent with the agreement or not. And if you try to enforce it, you have to go over that. And the remedies, other than specific performance, there are no remedies available under this agreement.
Why the qualification other than specific performance? Why isn't specific performance enough?
Because in a case of like visitation with a child, so let's say they take visitation away for months, and we have to file a brand new complaint, so because it's years from now, and it takes a year to get through this complaint, and this person's been deprived of a year with this child. There's no consequence for that.
But isn't that what the parties agreed to? I mean, if this is an enforceable contract, that's just the bargain the parties made. Somebody could have bargained for a different remedy provision, but they didn't. The parties agreed on specific performance. I mean, why does that invalidate the contract?
That in and of itself doesn't necessarily do it. I think that's then where the issue comes into play, where you also have a situation where, well, and that's where we do have to get to the factual determination, and maybe that part would require remand. So if this court decides that, you know what, on its face this looks enforceable, on its face it looks like that there is consideration, it's not illusory, and that it's probably in the best interest of the child, well then yes, maybe we need to go back and talk about whether there was a breach, or talk about whether or not the remedies are sufficient, or whether there was duress in using, basically saying, you just don't get to see your kid unless you agree to these terms. And that's a problem that I have. Now, I hope that's addressed the questions the court has to the motion to enforce. I would like to touch briefly, if I could, on the appeal itself. Given the limited amount of time I have, I just want to make this point on it, which is the salient point, the linchpin of the case, is that mothers are treated different. They have a different level of rights. They are treated different. And as this court mentioned in Bolden, the moment they give birth to their child, their fundamental liberty interest in that child is objectively apparent. And when we look at something like, for instance, a motion to intervene and the requirement that doesn't distinguish between mothers and fathers or mothers and anybody else, it becomes problematic because mothers are now being subjected to gatekeeping functions that are designed to operate towards the unwed father.
Can I ask you about that? Was there ever
Yeah.
a moment below where you asked the trial court to treat the answer as a motion to intervene or argue that it was the functional equivalent or, given what the statute requires to accompany the motion to intervene, you had satisfied that?
We did, and in fact, the district court specifically addressed that. If it's on the, it's in the decision in Appendix 4. The district
Did you
court-
do that prior to opposing the motion to strike?
We
Did
did.
you do
it.
that
Oh,
prior to the running of the 30 days that you had to move to intervene?
No, because what had happened is the
So
answer.
that's a problem, right? Because you have 30 days to move to intervene. An answer doesn't ask the court to do anything, and a motion does. And so there's a problem here. You haven't actually. So it's one thing to say we ought to look at substance and not form. We shouldn't just look at the caption on a paper. But the substance here, you never asked the judge within the 30 days to give you permission to be a party.
That's right. I see I'm going into my rebuttal time. May I answer Your Honor's question?
Yeah, the way we do it, just for benefit of all counsel, is as long as we are still asking questions, you're free to respond, and it will not cut into any of your time, either rebuttal or otherwise.
Fair enough. Thank you. I appreciate that. Yeah, so to answer Your Honor's question, the crux of the argument that we're making, though, is that it's unconstitutional to ask mothers to do the motion to intervene to begin with.
No, I know that that's a separate argument, but I was just sort of piggybacking off to Justice Pierce's question, which is, did you ever ask the judge to treat your answer as a motion to intervene? And your
Yes.
answer to that was, I think, later on.
No, sorry, that's not accurate.
Okay. When did you ask the judge
That
to
would have
treat
been
it?
part of, so there was a flurry of motions that happened. So what had happened is the answer went in before the 30 days, and then I believe it was a couple of days after the 30 days had passed that a motion to strike was filed,
Right.
in which we responded with an opposition to the motion to strike. We also did an alternative, a motion to dismiss, and then a motion to.
Let me see if I can refine Justice Pierce's question, or at least this is my version of his question. Before the 30 days ran, did you ever ask the judge to treat your answer as a motion to intervene?
No, we did not.
And isn't that a problem for you?
I don't think so. And that's because, again, that would only be true if we have to do a motion to intervene. If we don't have to do a motion to intervene, then it can't be a problem that we didn't do one.
Well, then we're to your constitutional argument. I
That's
think
right.
what Justice Pierce is asking about is there some way to rule in your favor without reaching the constitutional question? Now, I do have one alternative question along those lines for you. It seemed to me that one of your stronger statutory points, and I want to make sure I understand this point, and I'd also like to ask you a similar question, which is, did you preserve this argument in the lower court? Is the negative implication from section 120.14, which says implied consent under subsection 3A may not be withdrawn. And 3A is implied consent for abandonment.
That's right.
And so the negative implication of that would be other forms of implied consent may be withdrawn. And so when the statute speaks in terms of forfeiting your rights, that's sort of the equivalent of implied consent. And the idea would be that that kind of implied consent may be withdrawn presumably at any time prior to the termination of parental rights.
Yes.
Is that your position, and did you preserve that argument in the lower court?
Yes. So in addressing both of those questions, I'll kind of go in reverse order, how you presented them to me. As far as challenging the fact that we had the negative implication of section 120.1, paragraph 4, that was not an argument that was made before in the lower court. The position that had been taken, and this was all the way up through the Court of Appeals, was that in order for section 120.1 to operate to enter our client's implied consent, it required the operation of section 110 and section 112. In other words, it would require the court to find that strict compliance hadn't been made, And by that, the court then could strike the person or bar the person from the action and enter their implied consent. And the idea was, if those are unconstitutional and the court's finding and termination based upon that was unconstitutional, 120, which relied upon that, could not stand. You can't enter implied consent based on something that was unconstitutional. That was the argument that was brought up. It was not brought up in the context of, because it wasn't realized, quite frankly, if I'm going to be very honest about it, it wasn't realized until later that, oh, wait a second, if you look at this last paragraph here, it suggests, by negative implication, that in fact consent can be withdrawn. And so, and that
You
actually
did
came
make
up.
the argument that consent can be, or that implied consent can be withdrawn, but you didn't specifically point to that provision.
That's correct. That is correct. And so now that going to the first question that you had actually asked, which was, can this court reach the issue of dealing with the motion to intervene without reaching the constitutional issues? I think there's only one way for this court to do that, and that would be to look at the form over function approach. And to that extent, I understand and I appreciate where the district court is coming from. I recognize that the express language of an answer is not going to contain a prayer for relief that says, please let me join in the case. It's not going to contain that kind of language. But I think if we're looking substantively at what an answer is doing, it overall denotes the exact same function. It's saying, I am the mother, I have a right in this child, and I want to assert that right. Functionally, it's asking for the same thing. Because obviously there's no way to assert that right unless she's allowed to come into the case and assert that right. So to that extent, I think it's kind of putting blinders on to say, well, yeah, you filed an answer, but I don't know what that really means. I don't know what you're really trying to do when you file an answer.
Well, but I mean, the substantive difference is that a motion triggers a series of briefs and prompts a decision by the judge.
It does.
An answer does none of those things.
And that is true. And that's why I think ultimately we do have to get to the constitutional argument, though, because if we're going to look at that way and say, well, we can't really justify a form over function kind of argument because there would have been a benefit to the Averys had this been in the form of a motion to intervene, because then they could have responded within the 14 days and we could have had a reply in a hearing. Well, but when we look at it in the constitutional point of view, that's exactly what our precise complaint about this law is when it comes to mothers. And Bolden, this court's decision in Bolden, I think, is an ideal example of that. In Bolden, what you have is a gentleman who has timely and within strict compliance filed a motion to intervene. Not quite simultaneously that, but just prior to that, he'd filed a paternity action, but failed to file an affidavit. When he filed his motion to intervene, the adoptive parents objected to the intervention on the basis that because he had failed to file this affidavit, he had failed to preserve any right whatsoever in the minor child. The district court agreed and barred him from entering into the case. And then this court upheld that after drawing, and carefully I might add, after going through a long history of this court's different levels of scrutiny that it applies both to mothers as well as to unwed fathers, concluded that the unwed father was entitled to less protection, and because of that he was entitled to intermediate scrutiny, and based upon that, the fact that he hadn't completed the affidavit was a sufficient basis to keep him out. The reason I bring this up is this demonstrates, I think, fully the gatekeeper function of the motion to intervene. It fulfills those compelling purposes that the legislature laid out at the very beginning of wanting to avoid unwed fathers coming in and basically mudding up the process, slowing it down, delaying it, causing those kinds of issues, unless they have previously gone out and made some kind of effort to preserve these rights.
That's belied by part of the language of the statute, however, because the statute, in describing the notice, specifically mentions birth mothers.
It does, but that therein lies the problem, because you have other statutes where they're recognizing, for instance, the one we talked about earlier.
Well, much of the rest of the statute is devoted to
Right.
fathers, but the statute clearly contemplates that mothers are subject to this notice and obligation to intervene as well.
Right, but then it becomes, why is that necessary? How is that necessary?
But we don't get to second guess the necessity. The only thing we can second guess is the constitutionality.
But when we apply strict scrutiny, the least restrictive means test is whether or not that law is necessary to affect the compelling purpose. That's Thurnwald for you. That's your decision in Thurnwald. And so, in fact, in Thurnwald, what you had is you had the situation in which, just suddenly drawn a blank all of a sudden. Oh, that's right. This gentleman, they were unwed. The mother was pregnant. He was aware of the pregnancy throughout the pregnancy. He had attended some different doctor's appointments. He had talked to her about raising the child after it was born. They'd gone through all of this. Now, this entire time, he had the ability, and indeed I would say the obligation, to file the necessary documents to preserve his interest and rights in that child, but he declined to do so. And then on a Saturday of Labor Day weekend, the mother gave birth. Now she's obligated to give 24 hours before she signs consent, and she does that. Sunday morning, she signs consent. Now this gentleman's options are foreclosed, and it's Labor Day weekend. So the courts aren't open on Monday, so the earliest he can do anything is Tuesday, which he does. But then he is barred and ultimately denied access and appeals it. Now, Thornwald's a little bit interesting because it precedes Bolden, and so at that time this court still applied a strict scrutiny analysis, even though he was an unwed father. But what's interesting about it is that, and this is where I disagree, by the way, with the Avery's characteristic of this. They suggest that this is one of those holdings where the court found that the father, through no fault of his own, had been deprived of his rights, and that's not accurate. The reason he was in the situation he was in is because he waited until she gave birth, and she happened to give birth on a holiday weekend. He had plenty of time before then to do it, and he chose not to. It reminds me of a law professor who once told us, he said that the trick with procrastination is you have to know when the last minute really is. And that was this gentleman's problem. He didn't realize when the last minute really was. Nevertheless, this court applied a necessity analysis. Was it necessary to the state's compelling interest to deny him access when the child was born on a holiday weekend? And this court said no. It was not necessary. Therefore, he was entitled to an extra day. That was this court applying strict scrutiny and looking at it from a necessity lens. And so, yes, I think this court can and has an obligation to apply a necessity analysis and ask, is it necessary for a mother where it is objectively apparent that she has a fundamental liberty interest in her child, that she should have to go through the gatekeeper function of Section 110, doing the motion to intervene? The last thing I'll say about the motion, the section that Justice Durham pointed out, is I think the language gets a little problematic in there. And the reason I say that is because it's very clear in Section 110 that it's talking about adoption proceedings, not termination. It's talking about adoption proceedings. Termination comes in Section 112, which says you can combine the two. Now here's the curiosity of it. From my client's perspective, if she challenges the termination and she wins, so her rights are not terminated, by definition, the adoption can't go forward. So she really has very little incentive to combat the adoption. She has every incentive to combat the termination. But Section 110 doesn't talk about termination. It talks about adoption proceedings. This is where it gets weird. You go to Section 112, where it talks about the fact that you can combine the two, and then you get further down, and all of a sudden, the fact that she doesn't intervene in the adoption proceedings is grounds to terminate her parental rights, even though she was never required to do a motion to intervene on the termination part of her case. It makes no sense, especially in a statutory scheme that, in my view, clearly is skewed towards unwed fathers and is supposed to favor mothers, and that makes sense given their fundamental liberty interest that has long been recognized by this court and by the United States Supreme Court. So to that extent, I think when this court looks at what function does a motion to intervene serve, and is that function necessary to facilitate a compelling government interest in the context of mothers, the answer is no. She should have had her day in court, and that's all we're asking. Thank you.
Thank you, Mr. Holdaway. Mr. Gosnell.
May it please the court, Chief Justice, Justice of the Supreme Court, my name is Paul Gosnell. I am the attorney representing the adoptive parents in this action. I would also like to start with addressing the points of the motion to enforce and the mediation agreement that the parties entered into. Picking up with Justice Simonis's question as to whether we whether the law allows parties to reach a stipulation during the pendency of an appeal, I'm aware of nothing in the law that would prevent that. In fact, the case that we cited to specifically states that stipulations and settlements between the parties are to be encouraged. If the law were to treat those with hostility, it would be a very poor way of resolving disputes, requiring people to go through court. We've always encouraged people the courts have always encouraged people to resolve the issues on their own.
No, I don't have any problem. There's no question that parties can settle a case while it's pending on appeal. I think there is a pretty significant question as to whether they can use a pre-adoption agreement section in the statute to confer jurisdiction over an adoption court for elements of the settlement that they seem to have regarded as being available to them under the statute, which it seems to me doesn't apply in the first place.
Sure.
But maybe that's a relatively, that doesn't really go to the enforcement issue, I don't think.
No, I agree, and I agree that I don't know that we can obligate the courts to.
There is a way you could have
maintain
done this,
jurisdiction.
that this could have been done properly, it seems to me. Let me try this.
Okay.
You could have agreed to stipulate to a reversal of the adoption, the finalization of the adoption, and then under 146, gone back down and got approval from the court. And you could have also agreed that once that happens, that the party will not oppose adoption. So there is right, you see what I mean? You could have, I mean, you would have been risking non-approval by the court.
And the other problem with that is 146 specifically speaks to children that were at the time in the custody of the state, and that was never the issue in this case. So we may have still had some problems with 146 even in that situation.
That's a good point. That language is confusing. The custody had already been, even prior to the termination of parental rights, had been vested in the prospective adoptive parents.
That's correct.
Yeah. So that suggests that, I'm struggling with the notion that you all can agree to, without court approval, a division of time with the child and those types of things, that even in the kind of the family law setting requires court approval.
Right, and it was understood that the custody, there wasn't ever any issue of custody discussed in the context of that agreement. Custody was never talked about. It was just visitation, what type of visitation contact. There were play dates and gifts and things like that were addressed. So the issue of custody was never really something that was going to be addressed again by a court, or something that could be.
So you weren't envisioning your position, neither party was envisioning the court stamp of approval on this agreement?
Yes and no. We had anticipated presenting this to the court and asking for the court to find that it was in the best interest.
Under what authority?
Isn't that the problem? I mean, if one of the key elements of your agreement was to confer jurisdiction that you may have no power to confer, I mean.
Well, no, I don't think that we were intending to confer jurisdiction. I think the goal of the agreement was to resolve this dispute in a fashion that provided some prospective contact for the biological parents and grandparents, but also could resolve the appeal.
But would it have required trial court approval in order to be effective?
No, I don't think it would, because
what does it say? What does the agreement say about trial court approval?
I honestly, I don't recall.
It doesn't say anything about approval, but it does reference a best interest analysis.
Mm-hmm.
And-
By anybody in particular? I've forgotten.
No, it doesn't say that either.
I think the
provide
parties.
that? There's a presumption that the adoptive parents' best interest analysis is correct, but then.
Yeah, I think it was envisioned that
Yeah, that's
the parties
how
were
it's
agreeing that the agreement was in the child's best interest. I think is where we're
So
going at it.
I guess the two options are, one, if we find that at a level of, I guess, generality, these kinds of agreements are enforceable, one option would be to remand it on the theory that Justice Mona suggested, that a court always has the ability to enforce a settlement agreement. Another option would be, I think, a separate contract action. The court would derive its jurisdiction from a breach of contract claim or breach to enforce claim having been filed. And then it seemed to me that perhaps the parties contemplated that in that action, one of the contractual terms is that, that the visitation be in the best interest of the child, and that the court would be called upon at that point in making a breach of contract assessment to make that best interest determination.
I think so. I think that's an excellent characterization of.
And is
what
that
we
your
intended.
understanding, that latter characterization, your understanding of what the parties agreed to?
That's my, yes, that's correct.
So just,
So you think your understanding was you contemplated a separate action, or that this court, the same court that entered the adoption decree, would make the determination?
My thought was that we could bring an action under the adoption. However, the adoptions, once it's finalized, listening to the justice's argument, that just divests the court of jurisdiction. There's no ongoing jurisdiction over an adoption case. Once it's done, it's done, and in fact, it's sealed. So it may be problematic to revive that one, but that doesn't foreclose other options to either party. If there is a breach, either party could bring a new action to enforce this agreement.
but to be clear, the parties weren't anticipating any immediate court approval of this agreement.
That's correct. The only thing that we expected immediately going forward was that visitation was going to start, and once that started, there was phase-in visits, and once those occurred, that there would be a stipulation filed with this court to dismiss the appeal. When the adoptive parents attempted to provide the phase-in visits, were rejected by the biological parent. I mean, that's going to some extra record facts that might need to be looked into below first, but
But to be clear, so if the parties get along, in the parties' view, this never returns to court. This is the agreement under which the parties are going to operate, and if something goes wrong, they were just going to bring a motion for specific performance, or file a new action and then move to specifically enforce the agreement? I mean, is that the
Yes.
contemplated way it would have gone forward?
yes.
And so for all we know, there are agreements like this out there floating around, just waiting for problems to occur to come before the court?
I'm an adoptive parent. The first adoption that we did, we had a post-adoption agreement similar to this. It's never been an issue.
And one that wasn't blessed by a court, wasn't,
No, this was done back in 2007.
May I shift you to the
Sure.
the
To the
other
substance of the
yeah,
appeal.
the substantive argument, and in particular, why, do you agree that, albeit outside of the 30 days, that opposing counsel argued that it would be an abuse of discretion for the trial court not to have considered the answer to be a motion, the functional equivalent of a motion to intervene?
No, I don't believe that would be an abuse of discretion. And
No,
if I-
was the argument made?
Oh, yes. So it was not made within the 30 days. There was an argument that was made, and I can't remember which motion they filed it in, but it was post the 30
It
days.
suggested that it's in response to the motion to strike.
I wouldn't contradict that. I don't know if it was.
How
in
could, if that's the case, how can it not be an abuse of discretion for a court when you've got a biological mother who is clearly asserting through the answer her interest in her parental rights, and say, I'm sorry, you called it an answer versus a motion to intervene, and therefore I'm terminating your fundamental parental rights in this child?
Well, for one reason, I don't think it was discretionary at all. The judge was relying on the statute when he made that determination.
So if they don't title it a motion to intervene, that's the end of the argument?
No, it's not. I mean, they could
Well,
put.
the whole point of the motion to intervene is for the party to be required to signal to the court an interest in the adoption proceedings and a desire to be heard as the party. How does an answer not accomplish that
Well,
equally as well?
I think
I
fundamentally.
mean, granted, you want to call your documents what they ought to be called, but the purposes seem to be significantly overlapping.
Well, I think the fundamental difference between the two pleadings, I think that Justice Lee identified some of the fundamental difference, or maybe it was Justice Durant, about an answer doesn't trigger any response, doesn't trigger.
No,
a
but it
request.
does trigger
Right.
participation as a party and as an opposing party in connection with the relief sought
That-
by the plaintiffs in the adoption proceeding.
But that's the problem, is that she was not a party to the action. And that's why a motion to intervene is required.
Are motions to intervene by biological mothers, I mean, are they ever denied? Are there reasonable grounds for opposing them?
I have never seen one denied. Typically, if
Then why haven't you just shot yourself in the foot with that response?
because I've never had a mother file a motion to because she didn't file a motion to intervene. She didn't file a timely motion to intervene.
But the point of my question is to say, that was that sort of harmless error? You know, would it have made any difference if she had styled it as a motion? Was it the functional equivalent? I mean, yeah, what I said earlier is a motion is different because it triggers briefing and a decision. But now I'm sort of asking, would a briefing schedule have made any difference?
I think the difference, the problem that we run into is if we say that mothers aren't required to strictly comply, we've got decades of case law saying that biological fathers have to strictly comply with the requirements of the adoption code.
Yes, but the
If we turn
distinction the
around-
legislature has consistently drawn, and to some extent this court has upheld, is that biological fathers are putative fathers now. You can certainly raise some issues around that in the era of DNA, but these statutes and this treatment goes back well before DNA. In the case of a mother with a live birth certificate, the fundamental rights to parenthood occur at the time of birth. I mean, they arise by virtue of a person giving birth to the child. It's an objective fact that the child is the biological parent, which was never historically thought to be the fact with respect to the father. Now, again, maybe our law hasn't caught up to the reality there, but certainly with respect to mothers, that's the way it's always been viewed. So could the legislature legitimately place procedural requirements on a mother to establish her biological rights of parenthood, her biologically based rights to parenthood? And one of the things, frankly, that's of concern to me is that, you know, if giving birth to a child isn't enough to establish your rights to parenthood absent a finding of unfitness or abandonment or the other exceptions, what's to prevent, baby trafficking? You get your hands on a baby, you get into court, nobody files a motion to intervene, you proceed with an uncontested adoption, even where there's a known mother.
So there's a lot there. I'm not sure exactly where to start addressing it.
Well, you started with saying mothers and fathers are on the
Right.
same footing, and I was
don't think
pushing
the
back and saying, in the law, mothers are not on the same footing. And where's the rationale for not viewing these efforts to be represented as a party in an adoption proceeding? Where is there a rationale for not having a function?
So the rationale, and I think this goes back to what is the state's compelling interest in having this requirement. And when reviewing the case law, there is some statutory, in the statute it addresses some of the state's compelling interests in Section 102. But those have been further developed in the case law. In particular, looking at K.T.B, it addresses the state has a compelling interest in an adoption process that is that reduces the amount of contention or mitigates the contentiousness and uncertainty in adoption.
But adoption never trumps, the goals of
No.
adoption
And
never trump parental rights.
And I understand that. What the point I'm trying to make is that if we accept the mother's position on this, that mothers, just by their very nature, are always parties to an adoption, then that by its very nature is
No,
going
if
to
they
create.
get notice and they don't appear in any way, shape, or form, you can waive your parental rights.
Mhm.
But the question is here, she did respond in a timely fashion, but with the wrong kind of pleading under the statutory scheme.
And I just, with that, I just go back to the strict compliance. The statute requires strict
Well,
compliance.
on that point, if I could take you back to Justice Lee's question.
Sure.
So I think you've effectively acknowledged that mothers are granted intervention as a matter of course, where they file the motion, right?
If they timely file, and I should
So-
have made
so if
that
they timely file, so
clarification. I have seen them denied if they untimely file.
So, in light of that, how can you argue, first of all, as to the due process argument, that that requirement, that formal intervention requirement, is necessary to a compelling interest, and also as to the abuse of discretion question, if it doesn't rise to the level of a due process problem, how is that not an abuse of discretion? Even with strict compliance, you know, if we have a motion that is effectively a formality, right, why isn't it an abuse of discretion when there is something filed, like an answer, not to allow intervention in those circumstances?
Well, and I don't even know that the parties viewed their answer as a motion to intervene, because you'll see in the record, as soon as the motion to strike was filed, they subsequently, about 4 hours later, filed their motion to intervene. So I don't even believe they viewed the answer.
Well, that's just sort of prudent backup plan, right?
Sure.
Can I ask you about the implied consent
Yes, thank you.
withdrawal provision that I asked opposing counsel about? So what's your reaction to that? I mean, it seems to me that 120.14 pretty clearly says by negative implication that forms of implied consent other than by abandonment are subject to being withdrawn. That would then prompt the question of withdrawn when, and at least arguably the natural answer to that is at any time prior to the actual termination of parental rights.
Thank you, and I was really wanting to get to that. First of all, the argument of withdrawal of the implied consent appears nowhere in the record. It was not raised to the court below. This is a new avenue of argument that's being raised for the first time on appeal.
But the
However,
issue
to
was
address
raised, the
issue-
argument was raised to the effect that, look, allow me, Your Honor, to withdraw my implied consent. No?
That was never raised. If opposing counsel wants to point to the record when they come back up, I'd be happy to take a look at that, but that was never raised below. That was raised for the first time on appeal. But
So the argument was simply just to the may language, that there was some discretion? I mean, that point was made, right?
that point was made, and that harkens back to Section 112. There's no discretionary language in 120.
Okay.
Well, sorry, there is discretionary. It says that consent to relinquishment as required by Section 120 may be implied by the following acts. Now, if you go to Section 120, that's the section that identifies which parties are required to consent to an adoption, and one of those is mothers. And then we go to the section later on where it talks about consents once they're given. Section 126 says that a consent or relinquishment is effective when it is signed and may not be revoked. So in adoptions, we've long understood that consent, that 120.1 is saying we're going to treat it
But that's
implied
active consent, right? And that's different from
No,
that's
not-
different from implied consent, which is just passive activity like forfeiture.
The only difference that I can see, the code section says that it's treated the same. The only difference between implied consent and actual consent is that actual consent can withstand, can last prospectively forever. Implied consent only relates specifically to a pending adoption proceeding. So for example, if the adoptive parents had decided during the pendency of the action that they couldn't do this anymore for any reason, abandoned their petition for adoption, the implied consent under Section 120.1 would go away, whereas other consents when signed, and that's, I think that's the, sorry, all these adoption cases have initials. I believe that's the RBS case, where the biological father signed his consent, and then years in the future, the mother sought to activate it and use it in an adoption proceeding.
So you think that that's all 120.14 is getting at when it says implied consent may not be under subsection 3A, may not be withdrawn? That would be if
That's
an
the way,
adoption petition is dismissed and then a new adoption petition with respect to that same child is filed?
that's my understanding, that's my reading of the statute.
Not sure where to find that. I mean, it doesn't quite say
Well,
that, does it?
No, it doesn't, but it doesn't, it also doesn't quite say that it can be withdrawn. I was just pointing, I think that the code sections in the adoption statute are to be read together. So when I go back to 120 and then go forward to 126 and read all of those in conjunction with one another, it's apparent to me that consents, even implied consents, during this pending adoption could not be withdrawn. And for that matter, she never formally came in and requested that her consent be withdrawn. That's nowhere in the record.
Let me ask you one more question about the intervention versus answer. Envision a world where the district court gets a timely motion to treat the answer as a motion to intervene. District court turns to you and say, tell me what prejudice you would suffer, your client would suffer, if I deemed this answer a motion to intervene. What would you have responded?
So if I understand the hypothetical, you're saying that an answer is filed, and then subsequent to the answer, but prior to the running of the 30 days, a motion is filed to...
Well, let's not even say prior to the 30 days. Let's just say there's a request that the district court treat the answer as a motion to intervene, and the court asks you to identify prejudice that your clients would suffer if he or she were to grant that motion. What's your response?
The response is that the adoption codes are... We have these deadlines set up to where there's a bright line. We know at this point if nothing is done to trigger her request to intervene, we're moving forward with the adoption. The prejudice that my client would suffer at that point is now we were in an uncontested adoption. All adoptions are uncontested at their outset, and they only become contested if the proper party intervenes. We've turned this fundamentally uncontested, non-adversarial proceeding into an adversarial proceeding. So that would be the prejudice that they would suffer. Then there are issues of continual bonding with the child that could be disrupted as well.
But does the prejudice, I mean, does that look any different if it's styled as a motion as opposed to an answer? I mean, I get the prejudice in the sense that, yeah, if you let the mother intervene, then it's going to be a more protracted proceeding, and the adoption may not go through and all. But, I mean, I think Justice Pierce's prejudice question really goes to, is there prejudice in it being styled in form as an answer as opposed to a motion?
Yes, because we didn't, for this case in particular, we didn't know exactly what she was doing. If you look at her answer...
Really? I mean, when someone files an answer, isn't it pretty clear that they want to be treated as a party?
But she only filed an answer as to one part of the action. She didn't file any specific response to the adoption portion.
Well, but that's a matter for, motion for a more definite statement. You knew she wanted to be a party to the proceedings. You didn't necessarily know much about the relief she was seeking, correct?
That's correct.
But that's the only issue on the intervention, is getting into the case. Mm-hmm. You're in a motion to intervene, you're not required to say anything about the relief you seek or the part of the complaint you intend to contest.
Can I try it this way? What if you have a pro se individual who gets the notice and the mother writes back to the court, Judge, I'm a good mother, I don't agree to this adoption, and I want to have my day in court? Under your logic, she's out. And her fundamental parental rights in that child are terminated because she didn't put the words motion to intervene at the top of that statement.
And my response to that is that she's required to receive a notice.
I just want, yes, you agree with that in your world, she's out. She's pro se, I'm a good mother, I don't agree to this adoption, I want to be heard, but under your logic, she's out.
She would have, that's correct, because under the statute, she would have received notice that would have told her exactly what she needed to do.
Right? I mean, you're terminating her fundamental parental rights.
Well, and maybe I should back up, because 102, the very first two provisions in 102 speak to that best interest of the child should be at the foremost of every court.
But that can't replace the parent's fundamental right in parenting the child, to Justice Durham's point. I mean, it feels like not appreciating the significance of what you're asking this biological mother to do, and that we're based on really a stylistic point when it's clear to everyone that she's contesting the termination of her parental rights, that we should just go. for the life of me, I'm really struggling with how the district court, just on its own initiative, didn't treat this as a motion to intervene.
I mean, doesn't it happen with some regularity that trial judges get something in a pro se case like Justice Simonis' hypothetical and deem it a motion?
I can't speak to that because I haven't personally seen that.
I mean, our cases do talk about, substance over form and if in every respect except for the caption, the document received by the court is asking to be allowed to participate as a party, seems like it would be appropriate for the trial judge, especially in a case involving fundamental parental rights, to treat it as its substance indicates and not fault the lack of form.
Correct, and I believe that happened in NRA RDR that was cited in our brief where a biological father came forward within the statutory time frame, filed an objection, and was ultimately dismissed from the case pursuant to Section 110 because he didn't file a motion to intervene. And that was upheld by the court. I believe that's a 2011 case. So that does happen, and that is upheld. That position is upheld in the case law that I've reviewed.
Yeah, the problem is that, again, with putative fathers, they're several steps away from establishing parental rights.
Well,
And that's all they're being permitted to intervene for, is an opportunity to establish parental rights. And then when that's done, to get a hearing on the termination of those parental rights and/or the outcome of the adoption. With reflect to a mother with a live birth certificate, her parental rights are established as a matter of law, and it's an interesting notion that you then have to, once you've got those parental rights, that the motion to intervene applies in the same fashion to putative fathers and to birth mothers.
Yeah, just going back to the RDR case, they didn't even do an analysis of whether he had protected his rights. They said stylistically.
Well, it wouldn't matter. It wouldn't matter whether he protected his rights or not, unless he'd gone all the way through a paternity action. Because once again, all a putative father gets to intervene for is for purposes of establishing paternity and establishing parental rights.
I believe he was added to the birth certificate, so that was how he had perfected his rights. So he didn't have to do the paternity steps. His rights were already perfected as well. But because he filed an objection, he didn't style it as a motion to intervene, the court took the position that he didn't comply with the provisions of 110, and he was dismissed from the case.
And is it our law that the father's name on the birth certificate conclusively establishes parental rights?
It can.
It can, but that's my point. Does it always?
I don't know.
I don't know. I don't know
that
either.
issue.
But I do know that with respect to the mother, it does.
Well, Justices, I appreciate your time, and if there are any other
Hard
questions,
case.
I'm certainly happy to answer those, but I don't want to take any more of your time unless there's something specific you want to address.
Thank you,
Thank you.
Mr. Gosnell.
I'll submit on that.
Mr. Holdaway?
I don't know if this is particularly relevant at this stage, but it's not entirely clear what your client wants in these proceedings, other than an acknowledgement of the status of her parental rights. In the answer she filed, did she seek custody?
She doesn't, and Your Honor, the reason for
And
that.
I gather she still does not seek custody.
Oh, she certainly does. Here's the issue. So at the time that the adoption proceedings and the termination were filed, it was actually a co-guardianship with the Averys. And there is a factual dispute as to the access.
Between whom and the?
My client and the adoptive parents.
I see.
And there's a factual dispute that never was resolved because we never had a termination hearing as to whether or not she was being denied access to her son. The Averys would present that she had voluntarily abandoned and hadn't been around since I think it was November preceding the filing. Our client vehemently disagrees with that characterization. The point was this. Our position, the way we look at it is the parent really only actually has to challenge the termination, because if they successfully protect their parental rights, the adoption cannot proceed because their rights haven't been terminated. So when she answers, she specifically requests that the petitioners take nothing by way of their complaint, i.e., that they not get to terminate her rights. And so to that extent, I think that is sufficiently clear to put people on notice, one, that she's trying to be a party to the action, Two, that she's trying to assert her parental rights, and she's seeking not to have her rights terminated, at which point in time she could then go deal with the guardianship that had been put in place at that point in time, and that was what was going to happen. I think, if I could, just briefly, there was a question that was asked by Justice Pierce about what potential prejudice may have been suffered had the district court treated the answer as a motion to intervene. If I could like to touch upon that, because this is something that we actually did argue in front of the district court. To me, there is no prejudice, and here's why. Let's suppose that it had been done correctly, according to the statute, that within the 30 days, a motion to intervene had been filed. Well, now the 14 days kicks in for a response, another 7 for the reply, and then potentially an oral argument is set for some time later. We're looking well past the 30 days before a resolution just to the motion to intervene is decided. Then, because our client has a fundamental interest, because she's the biological mother, she's going to be allowed into the case, there's no question. She'll have to file an answer, which is what she's already done. So effectively, it was actually more prejudicial to go the other way about it and say, no, we should strike. Let's even put it a different way. Let's suppose that we'd filed an answer 10 days in, and then on the 29th day we said, oops, better get a motion to intervene in. We're still going to end up the same place we would have been had we just gone with the answer that was filed 10 days. So to me, there's actually not a prejudicial impact to that, because had we gone about it the way the statute delineates, in my mind, inappropriately from others, we nevertheless would have been well out beyond the point we were even then.
So if we rule in your favor on that basis, then the statute doesn't require a motion, it requires an answer.
For mothers. And
Right.
I want to be very clear on that. I believe that's true only as to mothers, because mothers have the manifestly apparent or objectively apparent right in their children. And to me, that's a big difference. In fact, if I could point to our brief on page 28, we delineate that the legislature has already held several different areas where, when it's very clear from the outset that the person's going to have a vested interest in this, we give them direct access to the courts.
Presumably, one of the issues on a motion to intervene would be whether the person who wants to be a party actually is the biological mother of the child, right?
It's not a hospital birth and not an immediate birth certificate.
And that could be true, and actually at a
I mean, might that be a reason for it to be a motion rather than an answer in case that's in dispute somehow?
I suppose that's a possibility. I think as far as this case is concerned, it doesn't apply, though, because in this one they not only
Yeah, I'm
allege-
just wondering about, one of the things we always have to wonder about is what precedent are we setting? What do our opinions say? And is there a slippery slope on down the line for some other case?
I don't think so, because here's the way the petition process normally works. As part of the petition process, the adoptive parents have to identify the people that are entitled to notice, including who the biological mother is. So they have to allege that. And when somebody files an answer, such as our client, they admit to the fact that they're the biological mother. And so, but nevertheless, even if, let's say, they don't make that express admission, when they're coming in with the answer, they're coming in because they have already been identified and alleged by the prospective adoptive parents as the biological mother. So I don't think it's really a factual question. Otherwise, that person wouldn't be there at all. Now, I think if you have somebody else in some really crazy situation who showed up and said, that's not actually the biological mother, I'm the biological mother, well, maybe we've got a problem. But I think that's a very, very...
That's a problem that exists across every single case where
Right.
somebody may be misrepresenting who they actually are.
Right, and I don't-
Whether it's a defendant in a criminal action, an adoption proceeding, a contract case, that's a problem with our system.
Well, right, and I mean, and you can't plan for every possible
We
eventuality.
don't
or
DNA
the fact that
test
somebody might
individuals
engage-
to ensure that they are
Yeah.
the named defendant.
that somebody might engage in improper conduct. I see that I'm out of time. If I can just briefly conclude with this thought. I told the court at the beginning that, to me, the crux of the case, and I think it's true both when we look at the motion to enforce and whether consent's validly taken, and then going all the way through and whether we look at it in a form of abuse of discretion or whether we look at it as constitutionality on a motion to intervene. The key to the case is that mothers are different. They just are. And that's long been held as appropriate. And in this particular instance, we had a mom with a son who had siblings, and it was summarily ended. And it was over the wrong document. Literally, that's all it took. And to us, that's just not a proper justice. So we'd ask this court to remand, please. Thank you.
Thank you, Mr. Holdaway, Mr. Gosnell. We appreciate your arguments. We'll take this matter under advisement, and at this time, court is adjourned.